Hello, and welcome back to the fourth Fatherhood Friday. It's actually the final one. It seems as if everyone is having some technical difficulties with our internet, all of the panelists. So we're hoping that this goes off with only a few hitches. As you know, having to work in this virtual environment creates challenges that are different than being able to be together. But we are so glad that so many of you have joined us. And over the last several weeks this summer, in these four events, we have more folks who have joined us than have joined us in the 4 years prior, all put together. So we're glad that you're here for this important conversation today. I wanted to do a little bit of housekeeping before we get too much further. Again, there might be some technical difficulties, and for that we apologize. But there is a place on your screen that allows you to click on a button and talk to someone who can help you who will provide a little technical support for you. We always know that maybe refreshing your screen seems to work as well, but apologies. There might be some delays and so forth with internet connections. You just never know what we're going to get. I promise that we will do our best, and so appreciate your patience and graciousness with that. We also want you to participate by sending us your questions or comments in the chat box. If you can, indicate your name and organization. We'd appreciate that. We will try to be responding to questions throughout, but several of you, many of you, sent in comments and questions prior, and so we'll be responding to those as well. So thank you for your participation, and we want to continue to hear from you. Today's event will be posted to the Fatherhood Resource Hub under the events page, where you can also see the 3 prior Fatherhood Fridays. And on the Resource Hub, been following this, you know that there's a wealth of resources for those who are trying to support fathers and families in general. And we welcome you to look at that site and to provide us feedback on improve it and additional content that we can add to it process. And we're doing it to support those who are trying to support our fathers and families. I'm Cynthia Osborne. I'm the director of the Child and Family Research Partnership at the LBJ School of Public Affairs at the University of Texas at Austin. And I am so privileged to be able to host these Fatherhood Fridays. We look forward to next year and hosting a Fatherhood Summit. And boy, do we hope that we're all back together by then. But we've learned that by being able to share in the virtual environment, at least in some capacity, expands our reach. So we will continue to do that and be able to check in with you year on and year out. We want to thank the Prevention and Early Intervention Division of the Department of Family and Protective Services in Texas. They are the sponsor. Provide so much support for programs across the state that are trying to support fathers and families. And so we are grateful for their ongoing support of this event and so many other things. Today, we're going to be talking about enforcement of access and visitation. This is an issue that I know is so important for so many families. I have had the privilege to talk across the state for over a dozen years about the issues that really matter to them. And usually I'm talking to folks about child support or parenting. But when it comes to being able to have access to your children, that's something that runs deep. I've heard concerns from both custodial parents and non-custodial parents. From custodial parents, I hear them talk about the fact that the father, usually the custodial parent is the mother. So I know that that's not always the case, but I'm just going to generalize for a second. But I do hear custodial mothers say, the dad was supposed to come, and once again, he didn't show up, and it broke my child's heart. And I just wish that there was a way that I could convince him to come and spend time with his kid. I've heard from a lot of non-custodial parents, especially non-custodial fathers, about showing up, wanting to see their kids and being turned away, or their children not being there and not feeling like they had a recourse. And that sense of disconnection from their children is just so difficult for them. The names of the programs, we have standard possession orders and access and visitation time orders. This is something that is not necessarily, it doesn't sit well with families, that they see themselves as the parents, non-resident, NCPs, CPs. We have all sorts of jargon. And these are moms and dads who, by and large, want to be able to spend time with their kids. And we're going to hear from a group of folks who actually work so hard to try and make that happen, especially when it's in the best interest of the child. The issue of violence is something that is always paramount, that we want to make sure that the children are safe. We never want to assume that all parents are dangerous. That is not true. But we do have screenings in place to make sure that if that is a concern, that that's addressed. But when that is not a concern, this is an issue that we are trying to make it so that parents are able to see their children, and that their children, we know, benefit from that so much. I'm joined by Leah Leone, who is the director of the Access and Visitation Department within the Office of the Attorney General Child Support Division. And she is a rock star and is a huge advocate for children and families across the state. We are so lucky to have her join us and to share what they are doing. But she's also moderator of folks who work on the ground day in, day out in their communities to try to facilitate greater access and vision arrangements between parents so that children really benefit. We're welcomed by David Simpson from the Harris County Domestic Relations Office, Mireya Cepeda from the Domestic Relations Office, as well as Joyce Garcia from El Paso's DRO. And again, so cool that they have joined us. Look forward to their conversation. So please join me in welcoming Leah Leone.
Thank you, Dr. Osborne. Good morning and welcome everyone, as Dr. Osborne said, to this July 24th edition of Fatherhood Fridays, where we'll be discussing access and visitation enforcement. Again, my name is Leah Leone. I'm the Director of Access and Visitation for the Child Support Division of the Office of the Attorney General. I work under a federal grant and I oversee grantees across the state who primarily help non-custodial parents with obtaining a myriad of services to assist them with restoring their parenting time and visitation rights. Here in Texas, I am proud to say that Texas is one of the most standardized statewide programs incorporating parenting time agreements into child orders. Parenting time arrangements are currently in the initial child support orders. So parents with a child support order also receive a parenting time order called a possession order. We join only a few states in those efforts. That background aside, I'm pleased to begin by introducing three of my esteemed colleagues and our feature panelists who represent grantee agencies in performing access and visitation services right here in Texas. Joining us, we have Attorney David Simpson from the Domestic Relations Office in Harris County, located in Houston, Texas. Good morning, David. How are you?
Good morning, Leah. Thank you for inviting me to speak about this important topic for families.
Thank you for joining us. We're so excited to hear from you. David, before you tell us all about your service organs, I'd just like to turn the page back and give a little information to our viewers and our listeners who may not know, but what exactly is visitation enforcement and how does it work?
Well, Leah, parents can agree to create their own visitation schedules outside the court setting, but only those parents who've secured a court order visitation schedule can enforce those terms in court. So in the context of today's discussion, we're only talking about cases where there's already a court order visitation schedule. And that court order is incredibly important because it gives the mom and the dad and the child a schedule, an expectation, an obligation of what must be followed. So the question you asked, if a parent is refusing to follow a court order visitation schedule, then the remedy may be going back into court and asking a judge to enforce the visitation order. And how do you do that? Well, the parent who's being denied possession would file a motion to enforce possession and access, seeking compliance with the visitation schedule and possibly punishment against the other parent for violating the order. The goal is to get the attention of the custodial parent so they understand the consequences of not abiding by the visitation schedule. And when a parent files a motion to enforce, they are requesting that the court exert its authority over the other parent and compel them into obedience to the possession schedule. That motion would list the dates and times that a parent was denied possession of the child. And following that last statement, as the motion itself is alleging the other parent has not followed the court's possession schedule, so must the visiting parent also follow the court order, which means for the dates they're alleging visitation denials, they must also be physically present to request their child on the right date and the right time and the right place. So it's very critical that the visiting parent understand the terms of their order so they can also be in compliance before they bring the action to the court. Because if they don't, that motion to enforce might be dismissed on a technicality. Denials of possession are only valid when the visiting parent is denied in person, which means the visiting parent cannot ask a court to enforce a possession schedule where they have failed to show up after being told by phone or by email or by text by the other parent that the visitation wouldn't occur. That said, after the motion is filed, it must be personally served on the other parent, which means that a process server has to actually place that motion in the other parent's hands. They can't leave it with somebody else. And the reason for this is because the motion to enforce is requesting relief that may include a denial of that person's liberty. Ultimately, there's going to be a court hearing where the judge hears evidence and rules on whether or not the custodial parent refused to comply with the visitation order. And if the court finds the other parent violated the visitation order, the court can impose punitive measures such as a fine, make the visitation time, jail sentence that's either imposed immediately or suspended, community supervision, or they can order the other parent to pay all the attorney's fees that were incurred to bring that motion to enforce. The goal is to bring the other parent back into compliance with the court's possession schedule. And once a parent's been held in contempt and punished, they are very less likely to not comply with the court's order going forward. It certainly gets the attention of custodial parents who, after a motion for enforcement is filed, understand the requirements of following a court order and the consequences of choosing not to do so. That's it in a nutshell. So I'm the executive director here, and we offer a variety of different services. In addition to offering visitation enforcement services for every family in Harris County that's adopting a child through a non-agency, we do the adoption evaluations. We invite parents who have high conflict in their lives to come in for parenting coordination. We offer mediations here daily for parents who have cases pending in the Harris County Family Courts, and our goal is to help moms and dads come together at one place and resolve their contested matters. We offer supervised visitation programs, and we also do child custody evaluations for moms and dads who can't agree on who will be the primary parent, and a few other things that we do here and there, including child support enforcement. So we offer a smorgasbord of services to parents who find themselves in the Harris County Family Courts.
And would you like to just tell us that during COVID and all of the changes that we've seen throughout our country and the world, are you still operating currently, offering those services with the changes?
Many of our services are being offered remotely, but they're all still ongoing.
Brilliant, that's wonderful. And what would you say, David, is the motivation for Harris County to offer these services in support of the clients that you serve?
We have a mission statement on the first page that's front and center, and it explains why we offer the services that we do for Harris County families. Part of the statement includes sentences like, We want to make sure parents understand and keep children out of parental conflict. We know that children deserve both emotional and financial support from both parents. And it goes on and talks about other things as well, but that's our motivation. We offer services on both sides of the spectrum, offering both child support enforcement and possession enforcement, and have done so since 1983. That emotional support for a child is just critical, and it only occurs when the child has actual time with their parents. So that's our motivation.
That's a wonderful motivation, and I'm so happy to be working alongside of you and our other panelists and others in the state. I want to shift gears just to talk about a few hot topics. You know, over the last several years, we've seen custody change a bit, whereas people were agreeing to standard visitation of first, second, and third weekends. We've seen a bit of a shift where parents are agreeing on 50 custody. How do you make that? Is that becoming the new norm that you've seen?
I see a lot about this in the press. I get a weekly blip from Texas family lawyers, and I am seeing some states begin with the presumption that a 50-50 possession schedule might be in a child's best interest, but it's still a few states that are doing it. So I'm not quite sure it's the new norm. As a percentage, few orders are resolved in Harris County with a 50-50 possession schedule. But to understand this trend, we need to look at three different ways that court orders are actually resolved. They are mediation, either a Rule 11 agreement, or finally a contested trial. And I mostly see these 50-50 possession schedules being implemented where the parties have participated in mediation or they've entered into a Rule 11 agreement. When parties reach a mediation agreement that provides for 50-50, a court has zero authority per case law to deviate from that agreement. Also, where the parties have entered into an agreement outside the court trial and the court is simply approving the agreement, if that judge sees that the parents get along, they co-parent well, that they live close by each other, and that 50-50 is in a child's best interest, the court's very likely to approve the agreement. However, if the parties don't reach agreement outside of court and take their case to a contested trial, for first impression cases, judges are generally still ordering and starting with our standard possession order. They'll quickly move to an expanded standard possession order if requested by the parents and there's evidence that the children and parents are well adjusted. But Harris County judges, and I also asked other jurisdictions like Dallas, are not at this point in time awarding 50-50 possession schedules from a contested trial. That expanded standard possession order seems to be the more common possession schedule.
Interesting. And thank you for that, David. I think that clears up a lot because I often hear about that in other states, as you said. And so I think it's important to bring that forward today. You know, in my involvement with access and visitation, I often hear parents speak of this notion that child support payments and the right to visitation are somehow linked. And by that, I mean, if the non-custodial parent or the non-residential parent doesn't pay, sometimes not always, the custodial or the residential parent denies visitation, though the other parent has a legal right to visitation. Are many of your clients seeking visitation enforcement dealing with this issue? And if not, what are the reasons that they're seeking your assistance?
I do think that's one of the reasons they do, yes. However, by law, they're not linked, but many parents choose to link them and use them as punishment against the other parent. And many times that's to the detriment of the child. Very unfortunate. By law, each parent has an obligation to obey the court order as it relates to either child support or visitation. A parent can't use that excuse in court. For example, you can't say, I do not have to pay my child support since I'm not able to see my child. On the flip side of that, a parent can't say, since the other parent's not paying their child support, I'm not going to allow a visitation. Both those actions would be in violation of the court's order and subject to counter motions to enforce. If you're a visiting parent and you're filing a motion to enforce visitation, it's certainly better to be paying your child support. First of all, if you're not, the custodial parent's going to respond to your motion to enforce by filing their own enforcement of child support. And that's going to shift the judge's attention away from only your case to being heard, looked at both cases. We always ask that question when we're prepping cases for enforcement. What are some of the reasons you asked why we see parties coming to our office to enforce visitation? We've already talked about a few of them, but we see other things. We see jealousy of new partners, anger about the breakup of the relationship or marriage, dislike of the other parent's family, wanting to replace that parent with a new husband or new wife. Those are the reasons we see denial of access. Extremely unfortunate. And we certainly in our office try our best to work through those issues and move forward towards a reality where both parents have time with their child.
It's so important as well. And I'm so happy that parents, especially in Harris County, which is a large county, have access to the services that you provide. And hopefully they can take advantage of mediating cases that have these sorts of issues to sort of figure that out. So thank you, David, for that information. I'm sure people watching this webinar will find that information quite helpful. I'd like to move on right now to introduce our other panelists. Today as well, we have Mireya Cepeda from El Paso Domestic Relations Office. Welcome, Mireya.
Good morning, Leah. Good morning, everyone. It is really an honor to be part of this series. I am a social worker for El Paso Domestic Relations Office, and I've been working there for almost 8 years. When I first started working at the DRO, we're not in enforcement services, and now I'm overseeing the social services department, which is called Family Court Services Division. And of course, it consists of workers and other staff, and we provide services, and among those services that we provide are enforcement services. We have, being social workers in the court system, we have that direct contact with parents that are going through the court system. Therefore, we hear their concerns, we hear their needs, and by hearing them, we often hear a question: what do I do? I can see my children, I have a court order, and the other parent is not letting me my child. In the past, we used to tell them, I'm sorry, we can do. But now, the enforcement services, we can tell them, apply for services. Why did we start providing services? Like I said before, there was so many, we could see that. In our previous director, she wanted to ensure that the DRO served both CPs and NCPs in various capacities. Significant complaints for the NCPs that they were not being allowed to exercise parenting time. So in 2000, we started providing enforcement. These services are under the Attorney General Access and Visitation Program. And this program is designed to help non-custodial parents establish and maintain active parental relationships with their children. And since 2015, we have received over 500 applications for enforcement services, and with the majority of the applicants being fathers. Enforcement services are an alternative to court action. It's important to clarify to the audience that when we provide enforcement services, we don't refer them automatically to court. The cases only get referred to the legal department in our office until all possible interventions have been set by the social worker. When we receive the application, I review the application, I make sure that it meets the criteria for this, and then we assign the social worker. The social worker is responsible for assisting the parents in resolving parenting problems and making sure that the applicant is not being denied time anymore. In order for this service to work, we need the commitment of both parents. So the social worker's job is to encourage the parents to work together, and we mediate a lot of issues between them, along, and we educate them. We had a lot of education on the rights and responsibilities, schedule, the consequences of violating orders, and of course, the importance of shared parenting. I'm very proud to be providing services in this program office. And I can tell you that the majority of the services that we provide and the cases that we close, they get successfully closed without court intervention. And we close them once there's an increase in the parenting time. So our motivation is to have both parents involved in their children's life, for them to understand that for children to be successful, they have to have both parents in their life. So for us, the greatest motivation and the best rewarding process is when we get to hear the parent tell us, thank you, I was able to see my child after not seeing them for a long time.
Thank you so much, Mireya, for that. And I'm so proud as well that the Office of the Attorney General has an access and visitation division within our walls. You know, without this service and without this program across the state, we can't imagine how many parents would not be able to see their children. So I'm so grateful to the work that you're doing as a social worker. I'm sure you've got your hands full, so thank you for your commitment and dedication. I'd like to also introduce your colleague, who is attorney Joyce Garcia. Good morning, Joyce. How are you?
Good morning. I'm doing well. Thank you for having me here. I am one of two attorneys at the Domestic Relations Office in El Paso.
Tell us a little bit about what you're doing each day, Joyce. What's your role there?
Yes. So I am part of the legal team at the BRO there, and the access and possession enforcements that come through my office are handled by me, and as well as modifications of access and possession, which is something new that we've recently begun. Like Mireya mentioned, there is a multi-step process in when cases come into our office for enforcement, because we want to make sure people understand their orders before it gets to court. Court is not for everybody. It's not the solution for everybody. A lot of times things can get resolved before it gets to that. But it is necessary for some cases, and that is what my team does. Once it gets to the legal team, we evaluate the case and make sure it meets the legal standards to go to court to become an enforcement, because the law does require certain elements to be met. The parents have to be trying. It's not enough to just know that the other parent is not going to allow you to see your child. You have to attempt to see your child, and etc. There are different elements that must be met. And then service is another thing. Unfortunately, we cannot proceed, like David said, without serving the other parent. It's just a due process. It's a due process. I think even the idea that you're going to court many times brings people to want to talk, because it becomes real for them. And I think that is really helpful too, because perhaps they were not willing to talk to each other. The parents were not willing to talk to each other when Mireya's team was talking to them, trying to get them to come together. But they do, once they are coming to court and they see the reality of the consequences to the situation.
Thank you so much for that, Joyce. I appreciate the work that you're doing. I'm certain that it takes a lot of expertise and skill, and so I'm glad that El Paso has you to help on the child team. So ladies, I'm curious to know, with you having done this work for some time, what do you think? Does visitation inducement really work? And if so, for how long? Once all of the issues are ironed out and parents are talking and things are getting worked out between them, do you tend to see that it lasts?
Yes, enforcement services work. In my experience, and as presented to you, the majority of the cases that we have, they get successfully closed without the need of court intervention. And once the increase of parenting time happens, we have learned in our experience is that providing parents with the tools to maintain a co-parenting relationship is more effective than trying to punish them or blame them. Either, it doesn't matter which parent. So what we do is that we provide them with information and resources in the community, therapeutic techniques that they could benefit from not only right now, but in the long term. A parent lends to for us, what we have learned to communicate effectively, it decreases the conflict. And once they understand and follow their court order, then the probability of denial decreases. Most of the time, we don't see parents reapplying for service. Of course, there's some parents that do reapply, but most of them, they don't. And now we see a lot is that we have parents that, although their case is closed, they will just call us with questions, concerns, something minor that they need assistance with, and without the need of having to open a case or without the need to have court intervention.
Thank you so much, Mireya. So, oh, go ahead, Joyce, please. Yes.
Sorry, I was quickly going to add, you know, from the legal perspective, from the legal department's perspective, what I see is a lot of times, as I alluded to earlier, we don't even need to have a hearing. Once the parents see I am about to face a judge, I don't know what can happen there. Because court is unpredictable, and they realize they need to start talking to each other and try to figure out what is best for the child. A lot of times they work it out without having to have a hearing, even after the legal department in the DRO files a petition, serves the parent who is not allowing the visitation, and takes it to court. Before we have a full hearing, parents oftentimes work it out. And in those cases that they do not work it out, we do have a full hearing. It does come to, our office does ask for probation, and probation officers monitor that the access and possession schedule, the visitation rights that are in the court order are being followed. And I've seen that work a lot, even in really difficult cases where the parents do not want to communicate with each other. I have seen that probation works if just the potential hearing doesn't work. Probation really has made a difference in my experience.
Thank you, Joyce. And just so I'm clear, you know, what would you say are the majority of clients that are initiating services? Are they moms? Are they mostly fathers? Or where does that land?
There are most of the patients we receive are fathers. Just to give you an example, in 2019, out of the 98 applications we received, 90 were fathers. So the difference, it's huge. However, I guess I can't stress this enough. The applicant is father. During the social services part of it, we do involve both parents, and we need the cooperation from both parents for the process to work. Do you want to add anything, Joyce?
Yeah, sorry, Mireya. I guess there's a delay and I didn't get answering. I've been there about a year and a half, and all of the applications that I have seen have been fathers. I have not seen any mother, but again, Mireya's department does see the cases before they get to me. So we might have seen some applications of mothers, but I did not see them until but they probably became resolved before they got to me. So I only saw applicant fathers.
Leah?
So I want to pose this. Yes, David, go ahead, please jump in.
Like El Paso, most of our applicants are fathers as well, but we also see mothers come in and they're seeking to enforce the flip side of possession schedule. The other parent didn't bring the child back on time or didn't bring the child back to school. So we've seen both come in, and our goal again is to try to work with both parents to resolve the issue outside of court. Occasionally, we also see grandparents come in and apply for services to enforce access, but primarily fathers.
Yeah, I appreciate that, David, that perspective on the well, right?
Yes.
Mireya, let me ask, what, if anything, do you say to the, being advised on from the social services perspective? How do you keep the father encouraged?
Well, Leah, let me start by saying that in my experience, parenting time is denied due to various reasons. Just to give the audience an example, we have parents being denied time due to NCP not paying child support, parents not understanding their orders, miscommunication or no communication at all between parents, unresolved issues when they were in a relationship before, and a lack of trust between them. So by saying that, the best advice that I can give parents, first of all, is to educate themselves. Education is key. Learning your rights, your responsibilities, understand your order. One of the most common issues that we see and that we identify when we first get the cases is that parent and enforcement services are not understanding their schedule, and they're not going on the right days or the right times, or even the correct exchange location. So that creates a lot of conflict. So parents have to be consistent. Parents who are following a schedule have to be consistent, because it doesn't help your case if you have a schedule throughout the year and you only go and try to see your child during the summer. So we tell parents consistency in your parenting time, because this will help your parent-child relationship, but also the relationship that you have with the other parent. Because I mean, you still have a relationship with the other parent. It's just a different type of relationship. It's a parental relationship now. So being consistent shows that commitment, that parent it's committed to being involved in the child's life, and it also shows respect for the other parent's time. Also improving communication, finding ways to separate the former relationship that you have to the parenting relationship that you have right now, focusing in that relationship. We often tell parents in our classes, turn your relationship in a slight relationship. Treat the other parent as your coworker, and you have a common goal, and your common goal is your child's being healthy, being successful, and be creative, finding ways to talk to the other parent. Because what may work for you may not work for the other parent. Because by having a good communication with the other parent, you're going to be able to identify what is preventing the other parent from letting you see their child. Because there must be a reason, whether it's a good one or not, there's always a reason. Okay? And a lot of the parents, you ask them, well, why are you being denied time? Do you know why? Most of the time they don't know. So the communication helps so they can identify why the denial is happening and giving options to try to resolve them. And let me just give you a quick example that a case scenario that often happens in our cases. The mother is denying time, and when the father asks the mother, "Why are you denying me time?" the mother answers, "I don't want Danny to go with you because I don't know where you live, and I can talk to Danny when he's with you." I knew initially wanna be like, "Well, I'm not gonna tell you. Why do I have to tell you where I live? This is not your business," anything. But if instead of responding that way, we try to understand their concern and put ourselves in their shoes, we respond with something like, "I understand your concern. I will be concerned too if I didn't know where my son was, or if my son was safe, or if my son was okay. Would it be okay with you if I have Danny call you every night before he goes to bed?" And by doing this type of things, you're demonstrating that you're listening to the other parent, and then you're giving the options to try to resolve it. And I know you may be thinking, well, what about the other parent? Why do I have to change? Why it's all on me? But when I'm not the one being denied time. And we have to remember that we only have control of ourselves. We cannot control what the other people do, and we're not going to be able to force them to do what they don't want. So listening to them, trying to understand, it's showing respect. Using words like please, thank you, morning, good night, and offering solutions is very important. And I'm not saying that you have to be friends, you just have to be cordial with each other. Remember that you're going to have to focus on your child right now. Whatever you're doing, whatever changes, whatever sacrifices you're doing it for your children. You're doing it for the other parent. You're doing it for the children. And just the last thing that I want to mention is that, of course, after all these attempts are not possible, you're not able to improve that communication and not to changes, then, and you continue to deny parenting time and you are following your court order, then just look for other resources in the community. Maybe there's a bureau in your county that is offering enforcement services, or anything else, maybe private legal advice. And yes, the possibility of it could be a lengthy process, but it may be the only way to have CP follow the. And that's what I have. Yeah.
Thank you, Mireya. I think that's very helpful information to give parents these tips. And I think the forefront of everything you said is to really not focus on the relationship and how it was between the parents, but more so to keep the children as the focus and what's best for them to method and try to find some consistency and normalcy. So thank you for that. I want to pose this question before we start taking audience questions to David and Joyce. What, if anything, David, do you say to the custodial parent who denies access and visitation based on non-payment of transport?
Well, first of all, we talk about the damage that they're doing to their child by doing so. That child needs a relationship. They need parenting time with the other parent to develop into a well-adjusted adult. And we would discuss with them the harm that they're creating in that child's life. We would also remind them that just as a motion to enforce can be brought for not paying child support, it can also be brought for not allowing visitation per the court schedule. In our office, we have a three-pronged process for enforcing visitation. And I'll just go a little deep into that if you don't mind, Leah. We always invite our applicants in, and they get to spend about an hour to an hour and a half with a lawyer, one-on-one. And for the first time, for many of them, it's the first time they've had someone sit down and help them understand their court order. Many of them don't have their court order in front of them, and so we give them a copy of it and go over it with them. And we want to make sure that they understand what's required. We do the same thing with the custodial parent. Then we invite them both in for a joint conference. And it's during this time that we would talk about the question you just asked. During that joint conference, we would discuss how neither child support and visitation are linked legally and how they're both critical as separate entities. And our hope would be to move both of the parents into compliance. We do those things well before we actually file an enforcement action. That's my thoughts on that topic.
I think that's a great point, David, to continue to allow parents to see the importance of both parents in a child's life. It's critical, really, to their growth and development. And so I'm grateful to hear that you actually offered them legal advice, because a lot of our fathers, most non-custodial parents, suffer through the inability to afford counsel. And so that's wonderful that in Harris County, as large as you are as a county, has the capacity to actually provide legal services. That's wonderful. Joyce, same question as David. What do you say to any parents that are residential or custodial who deny access and visitation for non-payment?
Well, Leah, we actually do see it a lot. That is one of the main reasons why they don't work out their access and visitation issues when they arrive at Mireya's department, and they have to be transferred to the legal department at El Paso's DRO, because maybe the father is not paying child support, and the mother is frustrated and sees as the only solution denying visitation in order to encourage father to provide that financial support, because it's hard for mothers, or for whether mothers or fathers, it's hard for parents to support the child on their own. But I think parents do have to remember there is more to, like Mireya alluded to, there's more to the parent-child relationship than just financial support. I think if parents remember that they have to think about what is best for the child, and if both parents are considered fit parents, really having a relationship with both parents is going to be better for the child. They're going to be able to grow in many more ways than if they only have a relationship with one parent. So the law, I think, I think that is the reason why the law specifically separates access and possession and child support, because one does not have to do with the other. And when we talk about court, when we take this defense to court, when a mother, let me explain. If our office takes this for enforcement, and the mother is the one we're enforcing the order against, and she says to the judge, I need him to pay child support, and that's why I'm not allowing visitation. That is not going to work as a defense, because the law does not allow for that defense. And I think precisely because the law looks at the child's best interest and the quality of life that having both parents in the child's life provides. So I think that parents to focus on that and put aside their own conflict. They if they think about the potential consequences of not allowing visitation, if the father takes the case for enforcement, now you have a judge, a stranger, looking at your case. You have a perhaps probation officer looking at your case and becoming involved in your personal life and checking up on you. And And then the potential expenses of all of that. Court can be expensive. There are court costs, there are lawyers. Maybe you want to get a lawyer. Maybe the other parent will ask for you to pay their attorney's fees in court, and that could be ordered by the judge. And now you not only not have the child support payment, but now you have those other expenses associated with all of this. So I think if there are issues with payment of child support, denying visitation is not the way to go. It is not going to resolve your situation and may only make things more difficult for you and the child as well, because if the child does not participate in the court proceedings, seeing their parents stressed about this is going to affect them in some way or the other.
Thank you so much, Joyce, for that. I really appreciate it. And I just want to put the pin here that with everything that you're doing as grantees with access and visitation, the Office of the Attorney General and Child Support Division, we do a lot for our fathers and our non-custodial parents as well. That's why we exist as access and visitation, to provide these support services, because the Office of the Attorney General cannot enforce visitation. And that's why we exist, to help these customers as best we can. And so I'm just grateful that these resources do exist. I hope by today's conversation that more people will reach out to the Office of the Attorney General and to ask what support services exist, and also that they will find you at the conclusion of this webinar. So again, I'm grateful to have those services highlighted. I want to take a from the audience. We've gotten a few. And so one question is, how do you see the laws surrounding visitation and custody changing in the future? Do you think that fathers will have more autonomy or more ability to be the custodial parent? David, you can take that one.
That's a challenging question, Leah. Looking into the future, I certainly think that we have, as time passed, recognized more and more how valuable and how important fathers are in the lives of their children. And I think that time has debunked some of the theories that were out there. You know, we have that theory that young children are better in mom's care than in father's care. And there are a lot of denials of possession for infants because there's an unproved theory that fathers can't change babies' diapers, can't make for them. Those tender years doctrine is what I was trying to say. Tender years doctrine. It really has been debunked. Fathers are able to take care of children from birth on. So I do see, with the changing of perceptions, because they are perceptions, they're not reality, that fathers are going to have more and more involvement in their child's life. Look at our custody orders now. Not talking about visitation and access. We're seeing more and more fathers become the primary custodial parent as time passes. And that by itself is evidence that as time moves on, we'll find more and more ways to bring forward an equal playing field so that both moms and fathers have equal parenting time in their child's lives. The challenges that come about are when we have moms and dads who just have high conflict. Are they too far from each other to facilitate the daily life of that child, getting that child to school on time, without driving across town, picking that child up from school? There are still some challenges, but when parents can get along, when they live close to each other, I think there's a solution to the problem, and I think the future holds great promise there.
Thank you, David. And I think you're right. And I think the paradigm is shifting, right? I often encourage our fathers that I come in contact with to see themselves as resources outside of their financial ability, to insert themselves in their children's lives, that they may play a greater role, because we know that fathers have a lot to offer. Working with the mom in that way is just a greater benefit when we have both of those parents involved in the child's life equally. And so that's the point of this entire webinar. I have another question. Can the Domestic Relations Office help people who don't have a possession order, or do they need to hire a private attorney?
Well, I'll take that, I guess, to start off with, and then we can move to El Paso. We can, in limited circumstances, like the Attorney General's office, we offer services to establish paternity, or we offer services in what's called suit affecting the parent-child relationship. So we can bring an action here by application that would establish a possession schedule. It would establish all of the different terms relating to a child, like medical support, custody, possession access, child support. But yes, we can here. Most of those cases, though, do go to the Office of the Attorney General. You guys do that well, you do it swiftly. But if we're asked to, we can. The difference is that we will charge fees for delivering that service, whereas it's free at the Attorney General's office. Those cases can be highly complicated, but we recognize the importance of them.
Thank you. And Joyce, the same for El Paso as well. I want to get to another question, but I wanted to weigh in with you first.
As far as the legal department, we only enforce and work off of already orders that already exist. Mireya, on your side of things, can you add a little bit to that? What services you guys provide before someone has an order?
Like you mentioned, with the enforcement services, yes, we will need to have a established order. We do have another service that is also out of the Attorney General program, and it's when they're going through the Attorney General hearings, like to establish child support and to establish a relationship, and even other cases, they can refer the case to us. We help them to try to mediate a schedule between them. So we help them create a schedule even as early as today, with days, times, specific change location, about holidays. So it's possible. It is possible to be done because we understand that there is a need to have established order in order to do anything pretty much as a parent.
Thank you so much for weighing in, El Paso, Joyce and Mireya. I appreciate that. Before we conclude and pass it back to Cynthia, I would like to share that, of course, in addition to all the resources that you've spoken about today, we have other grantees across the state. If you want to find out more information, you can call our very own, at the Attorney General's office, we have our very own access and visitation hotline, and that number is 866-292-4636. It operates every single day, Monday through Friday, with the exception of the weekend, from 1 to 5 Central Time. And there you can call with any questions about possession and access and visitation. You can be referred to many services throughout your community. It doesn't matter what county you live in. We have someone standing by to help answer all the questions you may have, in addition to what you heard here today. Is there any final thought before we conclude today? David or Joyce or Mireya, just a quick thought or a motivating statement for our viewers.
I wanted to say that when I first started talking, the question was about how you enforce your visitation. But I do want to say that we take in about 40 cases a month here. By far, the majority of our cases are resolved after parents come in and they're educated on the terms of their order, and they're given a chance to sit down across from each other and talk about why that visitation schedule has not been working, and given a chance to work through the issues that are there. We don't go straight to court. We do work through other methods to try to keep parents out of court, knowing that once you go to court, testifying against each other can be very detrimental to the future of you as a family unit, even though you're living apart. So most moms and dads are really agreeable, and they're able to work through the issues when given a chance to do so. And that's important to keep in mind.
It really is, David, and I appreciate that. This was certainly a pleasure for me, and I would like to thank my guests for sharing their time and expertise today. I know I diligently, passionately on matters related to access and visitation, But I could not do this work without the wonderful people representing Harris County, as well as El Paso County and all of the other counties and grantees that I work with and support and alongside of. And so David, Mireya, and Joyce, thank you so much for all you do for your community. Really appreciate it. And I hope that someone listening or watching was helped here today. And I think at this time we'll conclude and we'll pass this back on to Dr. Osborne. Thank you guys so much.
Thank you.
Well, thank you, Leah, and all of the panelists for sharing with us what you do in the domestic relations offices and how families can be served. Also, we will post the number for the hotline that Leah mentioned when we send out the post panel emails, so that you'll have the link to this event as well as that other information. And I know that this is a topic that cannot be resolved in an hour discussion. And I saw on the chat many of you wanting to hear from fathers themselves or mothers, wanting to hear from police officers and others. And this is an issue that goes deep for families, that to not be able to see your kid is something that I personally can only imagine how devastating that is. And it is important to know that the state has put in opportunities to try and resolve many of these issues. And there are issues that are going to take other methods in order to do that. And so I know that there's great frustration out there with regard to this issue, and appreciate that folks are trying to advocate for change. And but I'm really thankful for our panelists today to share with us what they are doing. And I encourage you to reach out to the hotline or to your local domestic relations office or to send your clients there, for those of you who are running organizations trying to support fathers, that this is a resource that hasn't always existed, and it is important to know that it is there. We're going to finish off today with a presentation that I pre-recorded on fathers and public policy. And I have been studying fathers for 20 or so years, as well as public policy. And it is an area that we need to learn a lot more about. But in this presentation, I provide a bit of an overview of how our policies have changed over time, just even in what the goals of the policies were, or what we thought about fathers and families, and how difficult it really is to get things right. And we are still needing to do a better job. Thank you again for joining us, and look forward to an ongoing discussion. Even though we won't be able to answer all the questions today, I do encourage you to continue to submit them. And these are issues that we will continue to address on our resource hub, as well as our subsequent summits. So thank you. And this is a presentation on fathers and public policy. I'm Cynthia Osborne, and I'm an Associate Dean at the LBJ School of Public Affairs at UT Austin. And I'm going to talk today about fathers and public policy. We have kind of a long list of things I'd like to cover in the 20 minutes or so that I have with you. But I think it's really important that we talk about how policies have really evolved to include fathers, and how we have a long way left to go. Finally, it seems that policymakers have noticed that fathers actually play a really important and unique role in their lives, in the lives of their children. The research is very clear that children benefit from fathers who are actively engaged in their lives, and that when fathers are absent, that the consequences can actually be quite severe and long-lasting for children and for the well-being of the family in general. And although it really seems to have made common sense to parents and children forever, the idea that dads actually mattered was not proven in the research until quite recently. And policy leaders have started to take notice of the societal and financial costs associated with not trying to support fathers being engaged with their children. And that this is better for children, for families, and for society. I think it's important, before I talk too much about fathers and public policy, is that one of the things that's difficult is defining what we mean by a dad. everyone knows what a dad is in their own mind, but from a policy perspective, it's quite different. Typically, when we think about mothers, we typically think about biological or adopted mothers who live with their children. When we think about fathers, they can come in lots of different varieties, and it makes it difficult to actually target effective policies well to each group or to the multiple groups. So yes, we can have policies that will help fathers who are married or living with their child's biological parent, or it could be a stepfather, both legally married or not married to the children's mother. It could be a single father who has primary custody of his child. There's also lots of different types of non-resident fathers who don't live with their children, but some are actively engaged and co-parenting well. Some are actively engaged with their child, but have absolutely no relationship with their child's mother. And some who don't live with their child are actually largely absent from the children's lives. And what we've learned from research is that often fathers assume multiple roles simultaneously so that they can be a non-resident father to one child and maybe haven't seen that child in years, but actually be living with, and the biological father to another child that they're married to that child's parent. So they can assume these multiple roles, and our policies haven't really been able to keep up or to determine what they're wanting to do for each of these. To be honest, most of our policies have really been to focus on the non-resident fathers who are either involved in some way or largely absent from their children's lives, with the idea that they can get these fathers to be more actively engaged and to contribute financially to their children. And what we've also learned is that the policies that we put in place may work really, really well for some of our fathers, but be disastrous for others. Child support is one of those in which, for the fathers who are divorced and have a steady paying job, child support is kind of like a tax. Every month there is an amount that's taken out of the non-custodial parent's paycheck, and it's distributed electronically to the resident parent. And really, there's no kind of additional work that needs to take place. But for fathers who don't have steady work, this policy of expecting a certain percentage of money from your income every month being paid can lead quickly to arrears and lots of consequences. So for any of the policies that we're talking about, they can be very different for different dads. And we also know that who's eligible for these policies differs quite a bit depending on which role you're playing. I'm going to spend a little bit of time talking about how fatherhood policy has really evolved over the last several decades, but things have changed quite a bit, and I would argue that we still have quite a ways to go. Most of the social policies that we have in this country were really developed based on the stylized notion that father is the breadwinner and mother is a homemaker. That, this is really not something that ever existed in the way that the Ozzie and Harriet or times of the 50s might have made us all think. There's always been a lot of variation in family form, and the families of the 1950s were actually the ones that were very different than those who came earlier and those who came later. But most of our policies had this idea, even before the 1950s, that, legally in a lot of our arrangements, both the wife and the child were actually the property of the man. And so if a father were to abandon his family by leaving for some reason or, divorcing in some way, it was usually a cause attributed to the father abandonment, and the state would step in to help some moms. I put here in quotations deserving mothers, because that was really the impetus for helping those who they felt were worthy of this help. They never helped single moms. They never helped moms of color. that this was really something to put in place to help those moms that we felt bad for because they had been abandoned by these men. And that was really where this idea of social welfare began. And the whole idea of fatherhood policy, mostly child support at that time, was to hold the dad accountable for financially supporting this ex-wife or his children. And really the idea was that they should do this so that the state didn't have to. The society really didn't recognize the role of the father beyond the breadwinner for quite a while. And even up through the 70s, 80s, and into the 90s, most of separations were due to divorce rather than folks who had not been married before. And the assumption was that you would try to replicate what the married household looked like, where the father was contributing the finances and the mom was contributing the homemaking, the caretaking for the children. So when they separated, the mom would keep the children and the dad would be ordered to put finances back into this household. And the idea of visiting your child was something that it could happen if the dad desired it or the families desired it, and it would happen periodically. But there really was a focus on the father providing financially to the family, again, so that the state wouldn't have to. These policies never really did recognize the reality of a lot of families, and particularly families of color. A lot of the policies that we put in place, such as man in the house rules and so forth, prohibited fathers from actually living with their children. If they were unmarried, this was something very difficult for them to do, to allow moms to be eligible for any sort of benefit. And we did a lot through public policy to actually undermine stable families. About 20 years ago, at the turn of this century, policymakers began to recognize that fathers were actually more than a paycheck. We started to actually study whether fathers mattered, and believe it or not, it came back that they did. And although, like I said earlier, this is something that most humans knew for a long time, most researchers, I'm a researcher, we had to convince ourselves through data. But policymakers started to pay attention to this. And there were also some alarming trends that folks were seeing, a real change in the number of children who were born outside of marriage, continued increases in divorce among some groups, and such that half of children will spend some time in their childhood without living with their biological father. So this confluence of us better understanding the role that fathers played and seeing that fathers were not as engaged with their children really started to change the way that we approached policymaking for fathers. Now, when we first started this idea of promoting father engagement, responsible fatherhood programs, it still was really to make it so that he could work and he could be engaged with his kid, because the idea is that if he was working, he'd make more money. If he was engaged with his kid, he'd want to provide more, and he would provide the child support and the government wouldn't have to. So we've still had that as an impetus of a lot of our fatherhood policy. But about 10 years ago or so, it really started to evolve even further to focus not just on fathers as a paycheck or their ability to provide or pay child support, but to start to think about also promoting parenting, father-child interaction. What do you do with your child when you're seeing them? And we know that the relationship that a father has to his child's parent or other parent, the mother of his child, the quality of that relationship really predicts whether he's going to interact with his child, whether he's going to provide for his child. And so the more that they could foster a healthy co-parenting relationship in which parents could make decisions jointly, that was a goal of these programs as well. Never have we really addressed the myriad needs that fathers have, and most of our social policies still largely target mothers or resident parents at least, but there really is some progress that's being made. And I think it's important that we recognize that we do need policies that actually both hold fathers and mothers accountable for being financially and emotionally responsible for their children, but also provide them that opportunity to do both of those things. I want to spend a little bit of time talking about how our policies that have been aimed at fathers differ quite considerably from those that have been aimed at mothers. And again, with moms, we kind of started with the assumption that she lives with her child, that parenting is difficult, and that moms are going to need some additional help in making that transition to becoming a mom, teaching them different skills. We recognize that she's going to need resources in the household to promote healthy child development. And if for whatever reason she's not able to provide financially for her child, there are a host of different sorts of benefits that resident parents can apply for. Again, nothing is as generous as what probably a lot of families need, but there are quite a lot of benefits. And yes, she has some obligations in which she has to perhaps work in order to receive those benefits, or she has to assign her right to collect child support to the state to receive those benefits. But the idea is that we know that parenting is tough and that it takes resources, and we've generated a group of policies that will help to support mothers. Again, more needs to be done, but that was kind of the impetus. Now, if we find that a mom, despite any of these resources, is neglectful or harmful to her children, the consequences are severe. The state will move in and remove her child, or perhaps try to ameliorate some of the problems. But that is her consequence. For fathers, the assumption is largely that he doesn't live with his child, and that really what he needs is help to better understand the importance of himself and the role that he plays in his child's life. And we want to help him build the capacity to work and to provide more for his family. I realize that what I'm talking about is more stylized than does not apply to everyone. And please also know that there's a lot of moms who do not live with their kids, and there's a lot of dads who do. So what I'm talking about is much more stylized in general, but it does apply largely for kind of where the impetus for a lot of our policy choices has come from. And for fathers, he is held accountable for providing for his children. Regardless of his own financial situation, we're expecting that he's going to find a way to work and to provide financially for his children. We don't ask anything of him when he doesn't live with the child emotionally. There's no expectation that he will see his child. We do allow for that, but he's not held accountable for seeing his child, and there's no consequence except to the child and his own emotional well-being. But there's no legal consequence to not seeing his child, only for not providing for his child. I want to give examples of two different programs that are kind of similar in the sense that they're trying to support parents, but very different in the way that they're executed and even kind of our goals for the program. Many of you have heard about home visiting programs, and these are programs in which a trained professional or paraprofessional goes into the home and works with expectant parents or new parents. The majority of the parents that are served are mothers in these programs, and it's actually funded through the Maternal and Infant Early Childhood Home Visiting Program through the federal government. So you can see even the name was really focused on that mother and child dyad. About $400 million annually is distributed across to all the states based on the need that each state has. And the states have to choose from a list of programs that have a strong evidence base. Like I said, the programs are really aimed at new moms, some fathers, but mostly to moms. And the goal is to provide moms with the support that she needs, the skills that she needs, the resources that she needs as she transitions to this new role. And the programs go on for years. They will, so long as the mom stays enrolled, many of the programs will last for 2 to 3 or even longer. more years. So someone comes into the house and works one-on-one with the mom. In the COVID environment, a lot of this is happening virtually, but it's one-on-one with some group meetings, but it's building that relationship between the home visitor and the mother that really seems to be such a value for these programs. The responsible fatherhood programs are somewhat different. Like I mentioned earlier, the impetus of fatherhood programs was to make it so the dads could work and they could pay for their kids. Things have changed a little bit since then. There is $150 million provided through the Healthy Marriage and Responsible Fatherhood grants that's awarded competitively to local communities or to states annually. Texas has some of these programs, but they're all throughout the country. They're different. Healthy Marriage is one group and Responsible Fatherhood is another, but some of the shared goals across those two different programs. There are three things that the programs must address. They have to help to build the capacity for employment. They have to focus on that father-child engagement or parenting skills, and they have to focus on cooperative co-parenting, or in the case of family violence, where it is safe, that they focus on what's called parallel parenting. And so they're not necessarily working together, but they find a way to both be the parent of that child in a safe, that's safe for the child and for each other. The programs do not target new fathers. In fact, they serve any father who will come into the program. And a large evaluation, kind of at a national level, found that the average age of who participates in this program is a 35-year-old father who has several kids. And by the time that our fathers are 35, I've spoken to a lot of them, they will have several kids, sometimes with multiple partners. They will often have quite a history of being formally incarcerated or having a difficult time with their work. They may have large amounts of arrears and back child support that they owe. They may or may not see their child or all of their children. So they come in with a lot of challenges. The providers, unlike in home visiting where they go through extensive training, sometimes they require professional degrees to be part of the home visiting, to be a home visitor. Most of the providers in fatherhood programs are not heavily trained in the program models that they often use. Many folks who are the providers have either some experience that allows them to really relate to the fathers that they're trying to serve, or just a great interaction and ability to connect with others, because that connection between the facilitator and the father seems to be something that's especially important for responsible fatherhood programs. The programs are very short-lived. They're between 2 to 3 months, sometimes with follow-up case management. But you can see that these home visiting programs and these responsible fatherhood programs, the amount that we invest and how they're set up are quite different from one another. Not only is it in our parenting programs that fathers are treated differently than mothers, it really, in lots of research that I've done recently with my team, we have looked at a host of different public policies. And what we know is that most of our social policies favor parents over childless adults. We really are a country that loves kids and we want to help kids, and we realize sometimes that we have to help their parents, and in order to do that, I wish that we realized that perhaps even more, but we don't do much to help folks who are childless adults. A good example is through Medicaid. If a state has not expanded Medicaid through, through the Affordable Care Act, then there is no Medicaid that is offered to any childless adults. For parents, there is a range of income eligibility thresholds. In Texas, you have to make, you could have income no higher than 17% of the federal poverty level, 1.7. That's the lowest in the country, the least generous in the country. But that's just for parents, and typically it's just for a resident parent. And so it will usually only apply to the mom. So like I said, our policies don't only just favor parents, they really do also favor resident parents who are mostly mothers. About 85% of resident parents are mothers, over non-resident parents who are mostly fathers. And a lot of our, well, really none of our policies take into account the time that a non-resident father spends with his children. So for instance, to receive the federal earned income tax credit, you have to be with, you have to have the child live in your house for 6 months and a day, or at least more than 6 months. And if the non-resident parent has that child for 5.5 months out of the year, he would not be eligible for that tax credit, whereas the mom who has them for 6.5 months out of the year would be eligible. So our policies really don't, it's all in for one parent versus really distributing it across both parents, unless there's some legal negotiation between parents of how they would split those after a divorce. In Texas, we have what's called a standard possession order. That phrase is not something that a lot of parents like, but that is what allocates the minimal amount of time that a non-resident parent is permitted to see their child. In Texas, if you add up all of that time, it is every Wednesday, every other weekend, or first, third, fifth weekends, some time at the holidays, some time in summer, and it's almost 40% of days. It's around 37%. And but none of our policies really take that into consideration. And in fact, fathers wouldn't be eligible for benefits as if they were resident parents. I want to talk about two policies that are really ripe for change. And we were just watching a great panel to discuss parenting time. But the intersection between child support and parenting time is something that I can't hear more about how much folks would like this to change. I haven't met a mother or a father who thinks that the system is working perfectly, or even people who work within the system. And again, it was set up at a time in which most of the folks who entered into the system were getting divorced. It was set up to replicate the breadwinner homemaker model. And today, the folks who are coming into our programs are much less likely to have ever been married. They have negotiated some sorts of arrangements that they informally have been living by. But this is a big system that when it's actually working well for kids, it provides a lot of money and it provides access for kids to see their non-resident parent. But when it doesn't work well, it can really make it difficult for families to negotiate. As was mentioned earlier, child support and parenting time legally are two separate policies handled by different jurisdictions or courts. You will hear again and again folks say, you don't pay to see your kid. This is different sorts of things. You have to pay your child support even if you're not seeing your kid, and you get to see your kid even if you're not paying child support. These things shouldn't go hand in hand. But in parents' mind, they are just intertwined like nothing else. And it's not just about whether you are paying or whether you're getting to see. It really is this kind of feeling that these two things are really both so important for how fathers or non-resident parents are supporting their child. Texas is the only state that simultaneously issues a parenting time order with each child support order. This is done pretty regularly in a family court system where in states in which there's a divorce and go before a judge and they'll have a child support order and a parenting time order. But in our child support system that is largely for unmarried parents, called our 4D system, we're the only state in the country that does this for every case. It even takes into consideration cases in which there's family violence. So the parenting time order might be 0 time, but it's set, and so therefore it's enforceable. But even if it's enforceable in most counties, as you heard in Texas and across the country, these different things are enforced in different courts. So families have to come up with the resources and the time to negotiate two different systems. There are some states that are having the default be of a 50-50 custody, where there isn't one resident parent and not the other non-resident parent. It really is that both parents have equal custody. In the states in which they are doing this, it's only for divorced parents who are not in the 4D system. And research is still inconclusive. We don't know that this is better. It seems that this is for families who make this decision, that that's what they want for their kids. It seems that it makes them a lot happier. We know that a lot of fathers have really been pushing for this because they don't want to be seen as the second parent or the non-resident parent or the non-custodial parent. They want to be seen as the father. And they've usually been the one who's the non-custodial. So we need a lot more research, though, to really understand the impact of this new custody arrangement. And families have to still negotiate what they're going to do about access to different benefits, because again, you have to have a child for more than 6 months in order to gain access to many of our public benefits. And this needs to be negotiated with parents who have this sort of default arrangement. And, you know, I have studied child support and parenting time for a very long time. And my recommendations are not recommendations that, you know, of any organization. They are just really my own thinking about these things based on my research and understanding. But I believe strongly that our child support system needs to do better to support the child, and that we have to take into account what the actual cost of raising a child is across two households. We know that it may not be quite as much as it is to raise a child in two separate households completely. But it's right now, we really only look at the cost of raising that child in the one household and ask the non-resident parent to supplement some of that cost, instead of thinking about the fact that that non-resident parent has that child with them for quite a big period of time. So we need to take those things into consideration. And we have to include childcare, because in order for parents to be able to work and to have their kids for any length of time, we know we need childcare. And the COVID pandemic has made that more apparent than any other time previously. Some states take into consideration the amount of time that the child will spend in each household. And this is something that I think is important, because again, it is not true that children just spend time with the resident parent. What we really want is that they are spending time in each household, and this needs to be taken into consideration. That said, though, enforcing that financially but not upholding that, that can be very expensive to the resident parent if the non-custodial parent never does come and see the child or provide those sorts of intangibles to the child. And we have to take into consideration what the parent's ability to pay is and what the parent's needs really are when we're setting child support orders. Our child support system isn't necessarily always flexible enough for families. I had one father say to me that when he lost his job and he was a non-resident parent, it took more than 10 months for his child support order to be amended in any way. And there wasn't an ability for him to pay what he had been paying previously. So he built up a bunch of arrears. He ended up in quite a big trouble with the courts because of this. Mom didn't want him to see his kid anymore because he wasn't paying. So there was a lot of tension there. And what his point was, that if they were a couple and that had happened and he had lost his job, they would have found a way as a family to contract and change what they were spending or how they were living. But when it's just his paycheck that they, set the order on, no matter what, in his case, the mom and the child were both financially secure. The mom was in a new relationship. They had enough resources. And he really felt that he wanted to be able to provide for his child, but he also wanted greater flexibility from the system that didn't really pay that flexibility to him at that time. So a more responsive system that takes these things into consideration, I think it's important. I also think that we have to really think about enforcing parenting time orders. And this, of course, has to take into consideration issues of violence and family violence, all issues of safety. That has to be taken into consideration. But we're seeing that there are ways that we can do this. And I would argue, though, that if we're going to enforce that non-custodial parents are allowed to see their kids when they should, we also have to enforce that non-custodial parents actually do see their kids when they're supposed to. And we haven't even started down that path. We just, as long as he's paying his child support, he would never have to see his kid. Maybe that's for the best in some instances. Maybe there's reasons that he's not around and the mom doesn't want him around. You know, there can be a lot of things going on. But I think that we have to think about it from the child's perspective. The child needs to know that both of their parents are financially and emotionally invested in this child, and that we as a society need to enable and hold accountable parents for both of those things. I also think that we have to think more broadly about our social policies and how we can extend them to non-resident parents and to childless adults. When we think about things like the earned income tax credit, both in New York and in DC, they are starting to extend an earned income tax credit to non-resident parents. In many states that have adopted or expanded Medicaid, they offer it to childless adults. And you know, that is really important for parents to be healthier when they, or for adults to be healthier before they become parents, so that they are healthier when they are parents. And all of this to kind of shore up the financial security, the health and emotional well-being of adults will help them to both prepare for, plan to become parents before it just happens to them. And it would enable non-resident parents to really be able to provide for their children, and their children are staying with them. I also remember a father who told me that you know, he wasn't eligible for many food stamps, at least not any sort of child allotment for that. And that he was embarrassed that he had to live in this studio apartment in a location that he wasn't proud of, very few benefits to help him in any way. And when his child came to visit, his child was disappointed in him. At least that's how the father felt. And that in the other situation where the child's resident family was, there was more comfort there, and you know, the TB and the whole thing. And he wished that there was some way that, you know, he could get some of the help that he saw extended to some other families, so that when his child was with him, his child would be proud of him. He had some disabilities that made it difficult for him to work. But regardless, again, our whole goal here needs to be that we're trying to think of the benefits that, or in the best interest of the child, and that we want that child's parents, whether they live with them or not, to have the financial resources, the emotional capacity to really be the parents that those children deserve. And policies can help to facilitate that. I wanted just briefly to talk about the fact that we have launched the Prenatal to 3 Policy Impact Center. And the whole idea here is that we want to be a guide to states as they develop and implement the most effective policies that really make it so that kids get off to a healthy start. The science is really clear about what children need and how important those first 3 years of life are to the developing brain and developing body. And that if we get it right then, boy, it has long-term positive consequences. Kids who are subject to lots of adversity early on struggle, and it's costly to society and to them. But states have wanted to make a difference and invest, but the solutions of what they were supposed to do have not been clear. So what we've done is conducted comprehensive reviews of numerous policies And we have identified what the most effective are, and we're going to be sharing all that information at our launch on September 15th, and invite you all to that. But one of the things that we really did see is that in all of the research that has been done to help us to understand what's effective at improving kids' outcomes, fathers are largely absent from all of this research and from the policies. And our goal is to try to shore up our understanding of how these policies will impact fathers and how that will also impact children. So please join us again on September 15th. I encourage you to register for this event and to be part of this whole kind of approach of trying to strengthen families and make sure that we keep fathers involved in this whole idea of what a family is, regardless if the father lives with the child or doesn't live with the child, or is in a relationship with the mom or not. That from the child's perspective, that we want to make it so that the child, when it's safe and when it is the right thing, which it most of the time is, that father has access to, that child has access to both of their parents who are both emotionally and financially ready to be the parents that the children deserve. Thank you. Well, I am grateful that you've joined us so far today, and I apologize for some of the audio or video lagging. It's internet connection issues. I'm grateful to the folks at the University of Texas who have assisted us with these presentations over the summer, and grateful to Bethany McKee and Eileen Dunn on my team who have done all the behind the scenes coordinating for these events, and it would not have happened without their careful attention. I know that today's discussion is one that leaves everyone with feeling a little bit empty and wanting more. And I'll do what I can to help to facilitate more of these conversations. But there really are changes that need to be made. And it's important to know the resources that do exist, and for us to think collectively how we can act and make changes moving forward. I do hope that you will join us at our next event at the Child and Family Research Partnership. Our Prenatal to 3 Policy Impact Center is hosting the event in September. You will get information to sign up for that. And like I said, we will be coming back next summer, hopefully in person. Boy, oh boy, would that be something if we're not. But hopefully in person so that we can continue these important discussions about how we can better serve our fathers, how we can make sure that our families are strong, all for the best interests of our children. So thank you again. Look forward to seeing you next summer, and look out for emails from us with more information to come. Have a great rest of your day.